Welcome to the deep dive. You send us fascinating sources, and we pull out the key insights, giving you that fast track to being really well informed.
And today we're diving deep into a really foundational case from 1897. The source is the House of Lords judgment itself. Salomon v. Salomon and Co., Ltd.
Okay, 1897, Salomon v. Salomon. Now, this might sound a bit like, dry legal history. It's about a bootmaker, Aaron Salomon, who turned his business into a company, and then, well, things went south financially.
They certainly did. But this case, it's fundamental. It really defined how we understand what a company is, legally speaking.
Right, because the big fight was about whether Aaron Salomon, the man, could be forced to pay the debts of Aaron Salomon and Company, limited when it went bust.
Exactly. The liquidator basically said the company was just Salomon in disguise, his alias, they called it.
So our mission here is to really get into those core legal questions. Why did this case go all the way to the top court? And why did this specific business failure end up having such huge, long-lasting consequences for basically all businesses?
There are definitely some twists, and I think you'll have a few aha moments about that separation between a person and their company.
Okay, let's set the scene. Aaron Salomon. He wasn't starting from scratch, was he?
No, not at all. He'd been running a successful leather merchant and boot manufacturing business for decades. It was solvent, thriving. A. Salomon and Co., that was the name.
And family was involved?
Oh, yes. His wife, daughter, 4 sons, they were all working in the business in some capacity. The eldest son was even a manager.
But not partners in the legal sense?
No, not partners. Salomon was the sole owner before the company was formed.
So why change? Why go through the hassle of setting up Aaron Salomon and Company Limited? What was the motivation?
Well, a couple of things seem likely. One big one was limiting his personal liability. If the business failed, his house wouldn't necessarily be on the line. That was becoming a more common reason to incorporate back then.
Makes sense. Any other reason?
Probably also to structure things for his family. Provide for them. Maybe make succession clearer down the line.
Okay, so he decides to incorporate. Aaron Salomon and Company Limited, nominal capital £40,000, split into £1 shares. Now, this next bit is really interesting, who actually held those first shares.
Right, this is key. The 7 shareholders required by the act at the time were Aaron Salomon himself, his wife, his daughter, and the 4 sons.
And how many shares did the wife, daughter, and sons get initially?
Just 1 share each.
1 share. That
Yeah.
seems minimal, almost like a technicality.
It certainly looks that way in hindsight, and it became a major point of contention later on.
Okay, so the company exists on paper. How did the actual business, the boots and leather operation, get transferred into this new company?
There was a preliminary agreement, kind of a setup deal, with someone acting as a trustee for the company before it was officially formed. Then, once registered, the company formally agreed to buy the business from Aaron Salomon.
Right, and the payment. How did the company pay Salomon for his own successful business?
This is crucial. He didn't just get cash. He received £10,000 in debentures.
Debentures, so basically secured loans to the company.
Exactly, making him a priority creditor. If the company owed money, he'd be near the front of the queue to get paid back from its assets.
Okay, what else?
He also got 20,000 shares, which were considered paid for out of the purchase price. This gave him overwhelming control, obviously, and the rest of the purchase price went to cover the old business's existing debts. Oh, and he was made managing director, too.
Wow, so let me get this straight. He sells his business to a company he almost entirely owns, gets paid largely in secured debt from that company, holds almost all the voting power, and runs it as managing director.
That's pretty much the picture, yes.
It sounds like he's still in charge, just with a legal shield. But crucially, from a purely legal perspective at that moment, had he done anything wrong according to the Companies Act 1862?
Well, that's the million-dollar question, or perhaps the 7,733 quota question in this case. According to the House of Lords' later judgment, no. He seemed to have ticked all the boxes required by the Act.
7 shareholders.
Check. Registered company? Check. Agreement signed? Check. And the judgment makes a point of saying all 7 shareholders, him and his family, knew exactly what the terms of the sale were, and they all approved it.
Okay. So, on paper, it looks legitimate. But as we hinted, things didn't stay rosy. The business hit trouble.
Yeah, the boot trade went through a bad patch. There were strikes. They lost some big contracts. Things went downhill fairly quickly for Aaron Salomon Company Limited. It became insolvent.
Right. And when the dust settled, what was the financial picture? How bad was it?
Pretty bad. There was a debenture holder, not Salomon anymore. He transferred them to Mr. Broderick, who got paid first because the debentures were secured.
So Broderick got his money back.
Yes. But after that, there was hardly anything left. About £1,000, maybe a bit more.
And the debts. The unsecured creditors? The suppliers, maybe?
They were owed over £7,700. A huge shortfall.
Ouch. Okay, so those suppliers, the unsecured creditors, they're left with basically nothing. What happens next? The liquidator steps in.
Yes, a liquidator is appointed. And instead of just winding things up, the liquidator goes after Salomon personally, launches a counterclaim.
On what grounds, if Salomon followed the rules of the act?
Well, the liquidator argued fraud. They claimed the price Salomon sold the business for was massively inflated by over £8,000, they alleged. They pointed out there was no independent board of directors.
Just Salomon and his family members holding one share each.
Exactly. And the core argument was that the company wasn't a real separate entity. It was just Salomon's agent, his puppet, his alias, designed purely to let him trade with limited liability while shielding his personal assets.
So basically accusing him of creating a sham company.
That was the essence of it, yes.
Yeah.
That he'd abused the corporate structure.
This goes to court. First stop, Justice Vaughn Williams. What was the argument there, and what did the judge decide?
The liquidator, possibly prompted by the judge, shifted the argument slightly. They asked for Salomon to indemnify the company, basically, cover all its debts to the unsecured creditors.
Why? What was the legal reasoning?
The judge bought the agency argument. He ruled that the company was essentially acting as Salomon's agent to run his business for him, but without the personal risk. Therefore, as the principal, Salomon had to cover the agent's debts.
So, round one to the liquidator and the creditors. Salomon is personally liable.
Yes, a big setback for Salomon. But he didn't leave it there.
He appeals, takes it to the Court of Appeal. What happens there? Do they agree with the agency idea?
They agreed with the outcome that Salomon should pay, but they actually disagreed with the reasoning.
Oh, how so?
The three judges there, Lindley, Lopes, and KLJJ, they didn't think agency was the right way to describe it. They preferred to see the company as Salomon's trustee.
A trustee. How did they justify that?
They felt the whole setup, the minimal shareholdings for the family, the debentures back to Salomon, was a scheme. A deliberate plan to get the benefits of limited liability and priority payment as a creditor, which they thought went against the whole spirit or intent of the Companies Act. They saw it as manipulating the law.
So, different legal label agent versus trustee, but the same result. Salomon's personal money is on the line.
Exactly. Still liable to indemnify the company. Two courts now had ruled against him personally.
So the final throw of the dice, the House of Lords, the highest court in the land back then, what was the absolute core question they had to grapple with?
Lord Halsbury, the Lord Chancellor, really zeroed in on it. He asked, was Aaron Salomon Company Limited a validly formed company, according to the precise words written in the Companies Act 1862? Nothing more, nothing less.
Forget the spirit or intent, just did it meet the requirements written down in black and white?
Precisely.
Yeah.
He stressed that courts shouldn't add requirements that aren't in the Act, nor ignore ones that are.
And applying that strict test, what did he conclude about the company's formation?
He found it was validly formed. The Act said you needed 7 shareholders subscribing to the memorandum.
Which Salomon had. Himself and 6 family members.
Right. Lord Halsbury pointed out the Act didn't say those shareholders had to be independent or hold a substantial stake or have particular motives. 1 share each was enough to meet the letter of the law. If the law was followed, a company was created.
Okay, so the company legally existed. What about the arguments that it was just an agent or a sham or against the Act's intent?
Halsbury dismissed those.
Yeah.
He basically said, once a company is legally formed according to the Act, it is a separate legal person. It has its own rights, its own liabilities, distinct from the people who formed it or own its shares. The motives of the founders didn't change that legal reality.
And the fraud claim, the overvaluation.
He threw that out too, at least in terms of defrauding the company itself. Why? Because all the shareholders, Salomon and his family, knew exactly what the deal was when the company bought the business. They all agreed to it. You can't defraud people who were in on the plan from the start.
So the court couldn't just say, well, we think shareholders should be independent if the Act didn't require it.
Exactly. Lord Halsbury made it clear. The court's job wasn't to rewrite the law based on what seemed fair in a particular case.
Lord Watson chimed in too, right? Was he on the same page?
Very much so. He seemed almost puzzled by the lower court's focus on the intent of the legislature. He basically said, look, the law sets out clear steps. Salomon followed them. How can you then say it's against the intent of the very law he complied with?
Good point. Did he address the creditors' situation?
Yes, he was skeptical about the fraud on creditors argument. He suggested that creditors weren't forced to deal with a limited company. They could have, and perhaps should have, checked the company register, seen the structure, seen the debentures before extending credit. They took a risk dealing with a limited liability entity.
What about Lord Herschel? Did he add anything new?
He really attacked the alias and agent labels used by the lower courts. He reiterated strongly, if a company is properly formed, it's a distinct legal person. Full stop.
And he saw wider dangers in the Court of Appeals ruling.
Yes, he pointed out that if this setup was deemed invalid, it could undermine countless other perfectly legitimate small private companies, often formed by former partners, specifically to get limited liability. It would create huge uncertainty.
He also mentioned the notice aspect for creditors again.
Yeah, he emphasized that the LTD, or limited in the company name, is a warning sign to creditors. It tells them they're dealing with an entity with limited liability, and they should act accordingly. They can check the register.
He did acknowledge the potential issue with vendor debentures, though.
He did. He noted that maybe the law should address the situation where someone sells a business to their own company and takes secured debentures, potentially leaving unsecured creditors out in the cold. But, he said, as the law stood then, it wasn't illegal.
Lord MacNaughton then gave quite a vivid account, didn't he?
Yes, his judgment is quite famous for its style. He really painted a picture of Salomon as a substantial, honest businessman initially. He stressed Salomon's motives weren't dodgy, providing for a family, expanding the business.
And he hammered home the procedural points again.
Absolutely. All formalities observed. He addressed the overvaluation claim again, saying, look, the shareholders, who were the only people involved at the company's birth, all knew the price. So no fraud there.
He also seemed to blame external factors for the failure.
Yes. He described the company's short life as basically bad luck, tough times in the trade, strikes. Not Salomon's fault, really. He strongly reinforced that the act simply didn't require shareholders to be independent or have a big stake. One share was enough.
And Lord Davy, his contribution.
He brought it back to strict legal interpretation. He conceded that maybe the lawmakers back in 1862 didn't specifically imagine a scenario exactly like Salomon's, but he said you have to go by what the law actually says, not what you think it should have intended.
He pointed out some specifics in the act.
Yeah, things like the fact the act didn't set a minimum value for shares, and it explicitly didn't allow trusts to be registered on the share register, suggesting the focus was on the registered members, not necessarily the ultimate beneficial owners.
And a nice logical point, too.
Yes. He pointed out the absurdity of the company itself suing Salomon, while simultaneously arguing that the company didn't really exist independently of him. You can't have it both ways.
So all 5 law lords agreed.
Unanimously. They completely overturned the Court of Appeal. Company's counterclaim against Salomon was dismissed. He was not personally liable for the company's debts.
And the huge principle this case carved into law.
The principle of separate legal personality and the corporate veil. A company, once properly incorporated, is legally distinct from its owners, its shareholders, its directors. Even if one person owns almost all the shares and controls everything, a one-man company, as it's often called.
So the company owes the debts, not the owner personally.
That's the fundamental rule established by Salomon. The company is liable for its debts. The shareholder's liability is limited, usually to the amount unpaid on their shares, if any. Their personal assets are protected behind that corporate veil.
What was the impact of this ruling? It must have been enormous for business.
Absolutely massive. It gave entrepreneurs huge confidence. You could start a company, take risks, try to grow, knowing that if it failed, you wouldn't necessarily lose your house, your life savings.
It encouraged risk-taking and investment.
Definitely. It made incorporating much more attractive and secure. Many argue it was crucial for the growth of commerce and industry, allowing capital to be pooled and ventures undertaken on a scale that wouldn't have been possible otherwise.
But it's not without potential issues, right? This strong separation.
No, it does raise questions. Does it sometimes allow owners, especially of small companies, to avoid responsibility unfairly? Can creditors sometimes be left high and dry because the company has no assets, while the owner who ran it into the ground is fine? It's a tension that still exists.
So wrapping this up, our deep dive into Salomon v. Salomon shows us this isn't just some dusty old case. It's the bedrock. It established that core idea of company separate from owner. It fundamentally shaped business law.
And hopefully unpacking the judgment like this gives you a real shortcut to understanding why that principle is so central and how it came about through this specific, quite dramatic legal fight.
Okay, a final thought for you to take away. We see the huge benefits of limited liability that Salomon confirmed, encouraging business, protecting entrepreneurs. But thinking about today, especially with small companies where one person might be the owner, director, and main employee, are the safeguards strong enough? Do we strike the right balance between encouraging enterprise and protecting people, creditors, employees, the public who deal with these companies?
It's that constant balancing act, isn't it? Something worth pondering. And please, do keep sending us your sources for future deep dives. Exploring these foundational ideas, like we did today with Salomon, really helps understand the world around us.